Um, it's wonderful to be here. This panel has, like in the Collegium, not been constituted with any transparency, but it's great to be part of it. I think that there are two aspects of the judgment relating to the Collegium that have actually been misunderstood or not invited as much attention as one might have thought. The first is that the judgment isn't a defense of the Collegium, and I think that that's really important. And actually, I mean, even though he's the minority judge in the case, I think Justice Chalmeshwar makes this point most clearly that the efficacy of the Collegium is not at issue before the court. And so I think it would be a huge mistake to sort of read the judgment to think that it's either a defense of the Collegium or it's a judgment on how well the Collegium has worked in the last 2 decades. And given that fact, I think that reading the judgment, you can sort of, there are two questions that naturally arise. One, has the court clarified how the Collegium works in any way? And second, given how the judgment has been framed and written and the order, how can we think about the Collegium looking forward? And I think the one really important, and I read this as a clarification of how the Collegium works, is that prior to the judgment and even in a lot of the arguments before the court and the commentary following the judgment, there seems to be a sense that judges are appointing themselves, and it's judicial exclusivity either de facto or de jure. And one of the things that's emphasized very strongly in the judgment is that this isn't true. And so both Justice Kehar and Justice Lokar spend a lot of time analyzing how the Collegium works, and they lay great emphasis upon the two memoranda in 1999 for Supreme Court and High Court judges and their appointments. And their argument is that, look, the Collegium isn't judicial exclusivity at all. The executive plays an important part of that process, and in response to the criticism that the Collegium doesn't work well, the executive has to actually carry as much of that burden. And there are 3 specific judges that aren't named in the judgment, but there's a discussion of them. And Justice Kehar very sharply sort of responds to the argument of the state and says, look, of these judges, you gave several of them post-retirement options, and the executive did that. Not a single objection was put forth. And so if there's a problem with the Collegium, that problem exists because of the executive as well. So don't look at the Collegium and say judges are entirely to blame, because that's not how the Collegium works. And that's the first clarification I think that the court issues, and is therefore able to frame the question at hand no longer to be one of judicial exclusivity, but now to be one of primacy. I think the second that comes out, and this is in Justice Kehar's as well, not in any of the other opinions, is that some of the arguments about the state were about legal reform. And what Justice Kehar says is, look, this measure is important, but it's really not at the heart of legal reform. And so if you're going to give us situations where riots have been committed and people haven't been convicted and so on and so forth, there are a lot of reasons that are responsible for that. For instance, the evidence at hand, investigative agencies, police reform, so on and so forth. And I think the second big clarification on behalf of the court is that it would be a mistake to equate Collegium reform with judicial reform writ large. And judicial reform is a much larger project. It's a much more long-term project. It's a much more fiscally demanding project. And in a sense, this is like the easy way out, right? And this is going to only settle, it's basically like saying that, oh, India has a higher education crisis, let's just set up 3 more IITs and then the problem is fixed, right? And the thing is that there's a lot of emphasis on that too, that a lot of the arguments about the Collegium, and so that's the second clarification I think that the court issues. I think the third is that the court seems to be very concerned with the fact that although transparency is important, there's a relationship between transparency and confidentiality and accountability of some kind that they felt hadn't been thought through. And to give you a specific example, one of the arguments that that Justice Lokar points to is that it was said that the NJAC proceedings and so on would be made public. And of course, this invites at least 2 concerns. One concern it invites is, what about the person who's actually being considered? He or she also has certain rights of confidentiality or privacy, and they may not want their rejection or application and so on and so forth be made public. The second sort of concern, and this is a concern around the world with such kinds of processes, is what happens when the person is rejected and the person is still a sitting high court judge, assume. How does that impact their professional career? Right? And in what way? I mean, there are reasons why you might think that it could actually be very problematic that suddenly this Delhi High Court judge didn't make it to the Supreme Court and is still having to hear cases. Does that affect their reputation? So on and so forth. And I don't think the court has a good answer to that question. And I also think it has a good answer for why it doesn't have a good answer to that question is because that's not the issue before the court. But I think the court points to the fact that the relationship between transparency, confidentiality, and accountability, those three virtues that you want to in some way balance and protect and preserve, is actually complicated and is going to have to be thought through in far more complicated terms than at least the NJAC proposal offered. I think the second, so that's one part of the judgment relating to the collegium, which is how it clarifies the working order. And the most significant clarification, of course, is that, look, this isn't judges appointing themselves. That's a sexy thing to say, and you might think that that's true, but that's actually not happening. And go read the memoranda. Executive can object. Why doesn't it object, right? I think the second aspect of the judgment is what room does it give to fix the collegium? Does it give any room at all? And I think, well, because it wasn't at issue, I think one has to be careful in a way to read that. But I think that there are 3 or 4 aspects of the decision that sort of going forward one needs to look at. One is, contrary to what Mr. Ramchandran said, it's what the court is looking for isn't primacy in the sense that the judges are the maximum from any institution. It's looking at primacy in the sense of decision-making power, that ultimately it decides. I think that's the key point, right? That so in that sense, it must be the body that can effectively say no or can effectively say yes and has the casting vote, as it were. I think the second is that there is some ambiguity in the judgment about what role non-judicial members can play. In certain instances, you get the sense that the court is disturbed even if non-judicial members have any kind of vote, right? That's one. And on the other hand, it seems to be that they're fine with any kind of vote. It is clear, though, that the judgment allows for advisory, consultative, participatory processes. And it does that in a way by saying, look, that's already happening, right? So it's not even that it gives you room to maneuver the collegium that way. It says that is already going on. I think the third aspect is that, and I think this is one of the things that can happen post the decision, is that there's enough room to maneuver the collegium to see that you have a better sense of criteria on which appointments are made, but I think there's much less room for individual appointments, and I think that that's kind of the key difference. So I don't think the judgment allows you to sort of open up a particular appointment and scrutinize it in that way, and maybe you can have some sort of greater guidelines, but I think what you get from the judgment that's clear is that the court in a way has to be the decision maker. I think what's less clear is what is the nature of participation. Is it just going to be advice? Is it going to be opinion on a file? Or is it actually going to be some kind of vote? Thanks.
Thanks.